contingency fee contract for legal services before approving such contract and requiring the Attorney General to approve such contracts. And with that, a bill brief from the reviser.
Thank you, Madam Chair. This bill would enact a new section of law that would provide that a political subdivision may only enter into a contingency fee contract for legal services if that governing body of the political subdivision calls a meeting for the purpose of considering the contract and provides notice of the items that you'll see on page 1 in lines 14 through 27. They also have to make a finding in writing that there's a substantial need for the legal services, the services can't be adequately performed by the attorneys of the political subdivision, and the contract can't be on an hourly rate basis because of either the nature of the legal matter or the political subdivision doesn't have sufficient funds. And also they're required to approve that contract in an open meeting after they've had that discussion that we alluded to earlier in paragraph 1. Before a contingency fee contract for legal services that has been approved by a political subdivision would be effective, the political subdivision would be required to obtain approval from the Attorney General's office. The political subdivision would have to provide a copy of the contract, a description of the legal matter, and a copy of the notice that was provided and the findings made pursuant to subsection A. Within 90 days after receiving that material, then the Attorney General would have to either approve the contract or refuse to approve the contract and provide the political subdivision with the certain reasons that are described. If the attorney doesn't take action within 90 days after getting those materials, then the contract shall be deemed approved. In a legal action where a political subdivision is represented by an attorney providing services under a contingency contract that violates this section, the Attorney General would be allowed to appear and request dismissal of the proceedings. And the court would be required to grant that dismissal if the court determines that the contract doesn't comply with the provisions of this section. Any contingency fee contract for legal services entered into before July 1st of 2025 shall be submitted to the Attorney General for review before July 1st of 2026. The Attorney General can either approve or refuse to approve the contract in accordance with subsection B. And then again, that provision on the legal proceedings. In this instances, the legal proceeding will proceed unless the Attorney General appears and follows the process for requesting dismissal. Subsection E provides the definitions that are used, and then finally subsection F would expire the section on July 1st of 2029. And I can take any questions.
Thank you. Committee questions? So this is an entirely new proposal. We don't have any process of review currently in Kansas. Is that?
That's correct, Madam Chair.
Thank you. I'm not seeing any. Thank you, Ms. Scott. Appreciate that. For our conferees, we have 8 wishing to testify on this bill. So 4 minutes per each conferee seems to kind of be a good amount that has worked in the past on bills. So we're going to allow 4 minutes for each conferee. And when there's a minute remaining, if you'll kind of keep an eye on up here on the chair, and I'll wave the folder, that means you have 1 minute remaining to kind of wrap up your statement and your thoughts. So with that, then we will start with proponent conferee Eric Stafford, Vice President of Government Affairs, Kansas Chamber. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of the committee. Eric Stafford with the Kansas Chamber, and appreciate the opportunity to be here today in support of Senate Bill 242. If you read our written comments, and I'm going to try to keep this under a minute so I can save time for Ms. Artman, who's going to be speaking shortly. But this issue first came about back in 2020 under then Attorney General Derek Schmidt. That version of legislation was essentially a prohibition on this type of behavior unless the sole discretion of the AG, he determined that they could enter into these contingency fee arrangements. So this version is a lot more prescriptive, it's a lot more permissive, it still needs AG sign-off, but it's also our understanding that the Attorney General's office has been in conversations with the League municipalities over language on that. If their representatives can speak to that today as well, it might give you a little bit further light into where those conversations stand. So we do appreciate your support of this legislation and be happy to answer any questions.
Thank you, and we'll reserve questions till after all the testimony. Next, we will hear from Jennifer Artman, partner, Shook, Hardy, and Bacon. And I'm sorry, Mr. Stafford, were you wanting to yield your time to someone else? Okay, here we go. Okay, so sure, we have about 3 minutes from Mr. Stafford, so if you want to have 7 minutes, we can do that. So
Thank you very much, Madam Chair. Members
Thank
of the
you.
committee, thank you for hearing from me today. It's an honor to be here to testify in support of Senate Bill 242. As Madam Chair said, my name is Jennifer Artman. I am a partner at Shook, Hardy, and Bacon in the Kansas City office. I focus my practice on product liability issues as well as civil justice issues. I am happily represented by Senator Corson in Prairie Village, Kansas. So thank you for the opportunity to testify here today. Senate Bill 242, you've heard the history from Mr. Stafford. I'd be happy to discuss more about the bill itself, but hope that the Attorney General's office and then others that are here today can speak to the impact of the bill. I'd like to focus on the twin goals of this bill, which are to facilitate coordination with the State Attorney General's office and the local governments that may be seeking the opportunity to bring contingency fee class action lawsuits in the state, as well as to provide transparency for those local governments whenever they're seeking to proceed on those actions. One of the ways that this bill works is to require the Attorney General just to have awareness of what local governments are doing in the state. We are seeing more and more often local governments are bringing the types of cases that require contingency fee contracts with attorneys. I think a quick summary of contingency fee litigation can help. So contingency fee litigation is often brought on a class action basis when there are lawsuits where individual damages might not rise to the level that would support an individual lawsuit. And what attorneys will do is seek to represent a large number of individuals that claim to have been harmed. By putting all of these individual cases together, it can result in recovery that allows the attorney to effectively proceed in that action on a class action basis. Now, the attorneys that do this, that proceed on a contingency fee basis, they are often seeking as their recovery or as their payment 30, 40, or even 50% of that recovery as their payment. So one reason we need to be careful with contingency fee class actions, particularly within the government range, is because the recovery, so much of it can go to attorneys in this case. Now, what Senate Bill 242 does and doesn't do is very important. First, it does not limit a local government from bringing a class action case where they're utilizing a contingency fee lawyer. All it does is ask that the lawyers be properly vetted and that there's no improper relationship between the political subdivision or its governing body and the lawyers that are being used to proceed on a class action basis. The second thing it does is make sure that a local government that's using contingency fee litigation is doing so to represent its own local interests. If there's overlap with a statewide interest, that falls to the Attorney General to protect the interests of all Kansas residents to be able to proceed on that action. The safeguards that are set into Senate Bill 242, which we heard described earlier, are good government policies. What they do is require a local political subdivision that hopes to seek to proceed on a class action contingency fee case is set an open meeting with a notice and an agenda where they want to discuss the action that would be proceeding, and then establish if there's any relationship between that political subdivision and the attorneys that are asking to proceed with the local government. Once that discussion has been held and there's a finding that the political subdivision would proceed with retaining attorneys for a contingency fee class action, then they would provide the contract that they've approved to the Attorney General, along with their written findings and a copy of the notice where they've discussed the contract at issue. The Attorney General then has 45 days to either approve or refuse the contract. And the first thing he does when he looks at it is the statute is written with amendments. It's 45 days. He would look at it and see if there is an issue of statewide concern or if this is one of a local government concern. If it is truly a local government issue, the statute directs that he is to approve the contract. Now, there are only 3 reasons that the Attorney General could say no to the contract and state that they would not approve it. And of those reasons, the first is that the state is already pursuing the matter in court. The legal matter is already being addressed. The second is exactly what we're looking to avoid here, is that this is an issue that's better represented on a statewide concern. The local government, by bringing the action, may have overlapping issues. They may undermine a state's position if it's something the state is proceeding on. And then the third reason the Attorney General may have the ability to refuse is if it does not comply with the rules of professional conduct for attorneys in Kansas. Now, interestingly, legal services is defined in the statute, and this is very helpful because it exempts out some of the work that our local governments are doing. Anything that involves bond counsel or attorneys that are assisting in the sale of property, those are local government concerns, ones that the state would obviously not have a general statewide interest in. So that is exempted from this issue here. You know, I think one of the issues that we're looking to avoid is something many of you may be familiar with. There was a lawsuit at Ford County in Kansas, brought a lawsuit against several petrochemical companies in late 2024. They were alleging that ExxonMobil, among other companies, were violating a Kansas public nuisance law with respect to recycling. Now, setting aside the value of that lawsuit and the actual substantive merits of it, this can cause issues because, one, it's only representing or claiming to represent the residents of Ford County. Would this not be an issue that applies to all Kansas residents? Second, if there was any sort of inconsistent verdict in that case that the state may try to utilize in a case of their own, it could certainly undermine the ability of the state to proceed. We'd like to avoid these types of situations, which are becoming more and more common. We're seeing local governments across the country take on matters that would typically fall to state attorneys general. And this not only overwhelms the courthouses, but it causes businesses costs in defending those lawsuits and takes away resources they could contribute to settling it or proceeding with their products. I'm happy to conclude my comments here. I'm also happy to answer any questions that anyone may have.
Thank you. Appreciate the testimony. Yes, if you'll be able to wait until we get to the end of testimony for any questions.
Thank you,
Appreciate
Chair.
it. Thank you. Next, we will hear from Roger Giboni, U.S. Chamber of Commerce, Institute for Legal Reform. Please introduce yourself and welcome to committee.
Good morning, Madam Chair and members of the committee. My name is Roger Giboni, and I am here on behalf of the U.S. Chamber of Commerce Institute for Legal Reform, or ILR, to testify in support of the committee advancing Senate Bill 242 for passage. ILR is dedicated to championing a fair legal system that promotes economic growth and opportunity, including here in Kansas. For years, ILR has monitored the rising trend of political subdivisions engaging with private contingency fee lawyers to bring lawsuits over matters of statewide and national concern. ILR has documented the serious problems caused when dozens or potentially even hundreds of government plaintiffs engage with profit-motivated private lawyers to bring policy-focused lawsuits against businesses. These lawsuits include ones over issues like climate change, social media, and as we just heard, plastics recycling. My testimony explains why each element of SB 242's proposed reforms is critical, and I'm hopeful that others providing supporting testimony today will detail the importance of transparency in the process of political subdivisions hiring contingency fee counsel. These requirements will ensure that Kansans are aware when their local governments engage private lawyers to represent them, and the consequences of that engagement, including the profits private lawyers would stand to gain at the expense of alleged victims. I would like to focus my oral testimony, though, on one central feature of SB 242, the mechanism that ensures the involvement and input and respects the sovereign authority of the state's duly elected Attorney General. Kansas's Attorney General is elected by the people of this state to represent them and their interests in courts. This is particularly appropriate when underlying litigation raises issues of statewide or national concern. Preservation of the rule of law and a healthy business environment requires predictability and the prospect of eventual resolution of litigation. As such, businesses anticipate needing from time to engage with attorneys general, including the Kansas Attorney General, on legal matters. But political subdivisions and private lawyers suing businesses over matters that were once reserved solely to the purview of the Attorney General turns that conventional process on its head and eliminates related efficiencies and predictability. Each political subdivision and their private lawyer comes to litigation or the negotiating table, prioritizing their own interests. And this guarantees that there will be uncoordinated and duplicative discovery, attorney's fees, and settlement negotiations. All of this makes it harder and more expensive for businesses to do business here in Kansas. And it ultimately prevents judgment awards and settlement funds from reaching those who are truly harmed in a timely manner. It also introduces the risk that the Attorney General's own policy priorities, investigations, and enforcement actions will be undermined by competing lawsuits from subdivisions that claim to represent some of the same people that the AG unquestionably does. Unlike the Attorney General, political subdivisions are motivated to seek recourse only for their small portion of the state, and their private lawyers are motivated to maximize their profits for clients and themselves. Equally as concerning, when subject to the outside influence of powerful activist organizations, political subdivisions can become vehicles for outside interests attempting to change policy through litigation. This undermines the role of lawmakers like you, elected to carry out that role. These unaligned incentives result in it becoming exceedingly difficult, if not impossible, for businesses to resolve claims in a timely manner. It also creates the possibility that very uneven recoveries will come to localities and in turn to Kansans. These outcomes are undesirable for businesses and Kansans themselves. SB 242 creates a process to ensure that the AG is aware of litigation that addresses matters of statewide and national concern, and as a result might interfere or conflict with his own efforts. It also provides the AG with the tools necessary to avert these obstacles and carry out his mandated duties. It is important to convey that SB 242 is common sense, good government legislation that will not close the courthouse doors to municipalities. They will continue to be able to engage in litigation over matters of local concern without interruption. This bill simply ensures that the sovereign role of the Kansas Attorney General is respected and preserved, and that all Kansans' interests are represented in a unified manner. In conclusion, we are aware that this issue of litigation by political subdivisions might be relatively new to Kansas, but our research shows that the threat is real. This legislature has the opportunity to act now to put meaningful guardrails in place to ensure this type of litigation does not take a foothold in Kansas. For these reasons, the U.S. Chamber of Commerce Institute for Legal Reform respectfully urges the committee to carefully consider SB 242 and advance it for passage. Thank you.
Thank you. Next, we will hear from Robert Hutchison, Acting Chief Deputy, Office of Attorney General. Please introduce yourself and welcome to committee.
Good morning, Madam Chair, members of the committee. I'm Robert Hutchison. I'm the Acting Chief Deputy Attorney General. And I'll spare you either a recitation of my testimony or repetition of the insightful testimony you've already received, and just touch on 2 points. And one is the transparency point that's already been mentioned. Not only does this bill promote transparency for constituents to know what their governments are doing and the contracts they're entering into, it also makes it easier for the Attorney General's office to see what kind of claims are being brought, purportedly on behalf of the whole state, if not the whole country, in areas where we typically litigate on behalf of Kansans. A lot of these cases are hard to detect and become aware of because they're often not even filed in Kansas courts. One was filed across the river in Missouri, one was recently filed in New Mexico, where a Kansas county is entering as a class action representative. This helps us become aware of these cases and helps us become aware of areas where maybe we need to be doing more investigation or we need to step in and take action on behalf of Kansas and make sure that we can continue to do so. The second point is there's also been an amendment reference which represents the efforts with our office and the league and the chamber to come across, bring some of our differences together and create a better result. You see a shorter timeline, for example, on review, so municipalities aren't waiting 90 days for us to get it back, and that's perfectly fine with the Office of the Attorney General. We definitely don't want them to wait to be able to assert the rights of their constituents when they need to. It also provides some clarity on the bases for the Attorney General's review, to make sure the municipalities know the grounds on which we are either approving or declining to approve a contract. So with that, I think everything else about the bill has already been very well said, and I'll be happy to stand for questions at the time.
Thank you. Is there anyone else wishing to testify as a proponent conferee on the bill? Not seeing any, then we will open it up for any questions. Yes, Senator Bowser.
Thank you, Madam Chair. And just, is it 90 days or 45 days?
Is that a question for the reviser, or was there an amendment to change it? Is that kind of what the balloon amendment we're talking about would look like? Sure, please reintroduce yourself. Thank you.
Robert Hutchison from the Attorney General's office. Yes, there was a balloon amendment that I think has been referenced a couple times. Let's see. And it got a couple of changes on each of the pages of the bill. And right now the bill is written says 90 days, but the amendment would cut it down to 45 so they get it back from us sooner. We'll
also need, for purposes of our record keeping, for the balloon amendment to please be submitted to our committee assistant, Barbara Moore, so we can make that part of the record.
We'll be sure to get that in. Thank you, Madam Chair.
Thank you. Are there other questions? I do have a question regarding the amendment while we're on it. Some of the opponent testimony talks about the amendment in particular that giving the office the right to veto the city's ability of cities to pursue litigation where, quote, the legal matter involves claims or issues that are more appropriately within the scope of state enforcement and the pursuit of the matter independently. And the concern from opponents is that it's too broad and would potentially prevent cities from pursuing the outcomes that would benefit the city's community. Has that concern been addressed by the amendment? Because the opposition testimony seems to state that it hasn't. So, and if you could reintroduce yourself, that'd be great. Thank you.
Yes, thank you, Madam Chair. Robert Hutchinson, the Office of the Attorney General. The amendment on it does try to provide more clarity when one of the initial grounds listed right now, ground 2, is pursuit of the legal matter by the political subdivision will not promote the just and efficient resolution of the matter. That seems very, very broad. So the language proposed tries to find more solid ground on which we would be able to, at the Office of the Attorney General, present a ground for declining to approve a contract rather than just and efficient. So the language proposed reflects that. But I think there's still going to be some ground for separation with the opponents in terms of the breadth of the review proposed by the office.
So there's still some ongoing discussion about the amendment?
We were just discussing before the hearing some potential for some additional revision, and we're certainly open to that.
Okay, great. And could you answer, are there other states that have this kind of review and oversight?
Madam Chair, I believe Texas does, and I believe there are other states that do as well.
And maybe that's a question for research, if other states have some sort of oversight like this. And one other question, not from cities, but from school boards, that the concern is it would remove decision-making authority regarding how to best meet the district's needs for legal services. And it cites a couple of Kansas statutes. Is this going to be deemed an appropriate exercise of the law and not infringe on decision-making authority of other entities of government?
Thank you, Madam Chair. I don't believe it will, especially if the contract that they're looking to enter into only affects the interest of that particular subdivision, like a school district, then it's not going to touch on the grounds in which the Attorney General's office can decline to approve a contract.
Thank you for clarifying. And you might want to stay nearby. We do have another question. I'm not sure who it's for, but Senator Titus.
Thank you, Madam Chair. I think I will direct this to Ms. Artman.
And please reintroduce yourself. Thank you.
Jennifer Artman.
Thank you, Ms. Artman. So there's a lot of discretion that the Attorney General has, and to just ask the question bluntly, some Attorney Generals may be willing to move forward with a meritorious case in an instance for political reasons or otherwise. Some Attorney Generals may not. That'll change from administration to administration. My concern as I look at this, and are we taking away the opportunity to pursue good claims that would benefit a community? They may have a statewide connection, but every municipality may be different, especially in a case where it's not in the political purview of the Attorney General to go forward with something. Aren't we taking away a fundamental right for protection of our citizens?
Well, Senator, I appreciate the question, and I think it's one to be forward-thinking. No, to me, this bill is balanced in its approach. And what it does, it applies checks and balances for local municipalities that want to proceed with class action or contingency fee litigation. It does require an Attorney General to approve, but only when those matters are of statewide concern, just like the prior question regarding the school board. If this is a truly local interest, the Attorney General is directed to approve the contract immediately. So I think it is still protecting those interests of the constituents within that political subdivision. As far as an Attorney General's appetite for class actions, we elect our Attorney General, and I would hope that he would seek to protect the interests of all Kansans whenever there's that opportunity to proceed on something that's of a statewide concern.
Thank you.
Other questions? Senator Corson.
Thank you, Madam Chair. And this may be part of the amendment. I don't know if this is specifically for Ms. Artman or whomever wants to best address it. I noticed that I'm on page 2, line 11, that one of the things that the political subdivision has to provide to the Attorney General is the copy of the proposed contract. I just worry if there are situations where that may contain information that parties would be reluctant to provide to the Attorney General being a kind of a third outside party, and if there's ways to provide maybe like a summary of the contract, or I'm just thinking that I haven't seen one of these personally, so I don't know everything that would be contained in a contract, but I just know that in general, when two contracting parties make a contract, that oftentimes they don't readily necessarily want to then turn over those contracts to a third party, which is what we'd be mandating. So I'm just wondering if that was any consideration for the amendment, if it could be a summary of a contract, or if it could contain certain key information that the Attorney General felt like he or she needed to have to make a decision, but to just mandate disclosure of the whole contract, I don't know if that was something that's come up in your discussions with the proponents and the opponents. Thank you.
Senator Corson, the fact that you're an attorney is showing, because we often think about confidentiality and especially the contracts that we enter into. It is listed, I believe, as the contract in the current balloon amendment, but I believe as those conversations are proceeding, the question of whether it should be a summary or not is one that could be addressed.
Okay, thank you, Madam Chair. I appreciate that answer. Thank you.
Thank you. With the bill as currently drafted, one of the requirements would be that the governing body of the political subdivision calls a meeting for the purpose of considering the contract. Would that contract then be a public record of the meeting?
I don't think that that is required by the current language of Senate Bill 242, but it would be held in an open discussion along with the other elements within the bill as it's listed there. But I would be happy to yield time to the Attorney General's office if they would like to discuss it.
Robert Hutchison, Office of the Attorney General. I believe under the Open Meetings Act, if the document was referenced in an open session, it would then become an open record under the Open Records Act. So.
Thank you. And we had a question from Senator Bowser.
Thank you, Madam Chair. And question is for Mr. Hutchison here. I know we'll get a chance to hear from Mr. Zimmerman here in just a minute, but I think he brings up a good point, or I had the same concern. And I'll quote from his written testimony here. He says, one of the concerns with SB 242 is that it greatly underestimates the sheer magnitude of contracts that would flow to the Attorney General's office. Do you have an estimated number of work that you would have to do, and would you have to hire additional staff?
Yeah, thank you, Senator Bowser. We have tried to pare out a significant chunk of the contract, such as with the collections exception and the bond counsel exception. If there are other areas that would create a great deal of work that are absolutely of purely local concern, we're happy to expand that list of what wouldn't have to come to us to make sure that it's really areas that just have the potential to touch on areas of state interest, areas where the Office of the Attorney General normally litigates, and not try to interfere with the operations of the local government.
And do you have any idea whether at this point you think you would need additional staff to handle potential additional work?
Senator Bowser, our anticipation at this time is that this would not require the hiring additional staff, and we'd incorporate it into the legal review we already do with regulations and interlocal agreements, that kind of thing.
Thank you. Senator Argabright.
Thank you, Madam Chair. He stole the thunder out of me right there. The fiscal note says no additional staff, and it seems like this might be a little overwhelming at times for the department. And that was my question, but it sounds like you answered it. It sounds like a lot of additional layers in your particular office, and then the downtime sounds a little significant to me on top of that. So I guess, but Senator Bowser asked my question, and I think you've responded. Unless there's more. Thank you.
I don't have any additional to add. Thank you, Senator.
Thank you. I have a little bit of a follow-up question, and maybe research has some answer about whether other states have enacted this, but that's kind of a big question, so maybe not ready yet. But on page 1, of the bill, some of the things that the governing body of the political subdivision would be required to do at the meeting is consider the qualifications, experience, and competence of the attorney or law firm selected by the governing body. How do you envision that that would work?
Madam Chair, I think that could happen with the representative from the law firm themselves presenting at the meeting about their background or qualifications, or a member of the municipal body discussing about the kinds of cases that this particular law firm has taken on, and even the results that they've had or experience representing municipal entities.
And there would also be some discussion about the nature of any relationship with the political subdivision and the attorney or law firm. The nature of any relationship, what's meant by that?
Madam Chair, it would be if they already have existing employment arrangements or contractual arrangements with the municipal entity.
And you mentioned Texas has a law similar to this. Does it have these same sort of requirements that you and I have just discussed and that are in the bill?
Madam Chair, I haven't actually reviewed the Texas law to go line by line, so I don't want to assert something I'm not certain about. But I know that I do believe it served as something of a model for this bill at its foundation.
Thank you. Are there other questions? I'm just trying to determine how it's been working in practice in other states, if it has been tried there. So yes, other questions? Not seeing any, then thank you very much for your testimony. We will next hear from neutral conferee John Goodyear, General Counsel, League of Kansas Municipalities. Please introduce yourself and welcome to committee. And we'll do the 4 minutes again. Thank you.
Thank you, Madam Chair, members of the committee. My name is John Goodyear, and I serve as General Counsel of the League of Kansas Municipalities. Grateful for the opportunity to appear today and to give some thoughts on this bill. You've heard what it does. It requires a city or public agency to submit contracts for legal services on a contingency fee basis to the Attorney General's office for review and approval. Just as a starting point, as a broad concept, and with the bill as written, the League is opposed to this. But in recognition of the competing interests of the Attorney General's office, there are going to be times where there is a need to facilitate public interest litigation with a united front in the state, and that is within the office of the Attorney General's purview. So in acknowledgement of those competing interests, the League reached out to the Attorney General's office, who's been great to work with on basic amendments that can make this more workable for our members and make it more workable for their office. So opposed to the bill as written, but provided that amendments are made, the League will be neutral on this legislation as it moves forward. And I think a number of cities that submitted testimony are in the same position. I do know that we have cities that will just be opposed to the legislation. So again, we're grateful to the Attorney General's office for their work with us. Through our discussion, we've been able to refine this legislation quite a bit. So I hope once you see the balloon amendment, I apologize that it hasn't gotten to the committee members yet, but once you see it, the bill makes a little bit more sense, I think. We actually created a definition for legal services. So the number of contracts that are going to be going to the Attorney General's office is going to be limited quite a bit by that definition. It's going to ease up their review burden, and it's going to have contracts that have nothing to do with what they want to take a look at. It's going to stay out of their office. For example, often contracts with bond counsel are conditioned upon the issuance of bonds. The Attorney General doesn't have an interest in that for the contingency fee basis. Often cities enter into contracts for debt collection. The Attorney General's office doesn't have any interest in that legislation or in those kind of contracts. So keeping those out, keeping those off their office. We also shortened the time for the AG's office to review the contract from 90 days to 45 days, and they think that will work. We also made an automatic approval for when a matter is presented that is purely of local concern. So we're just talking about those bigger statewide national issues that are going to be subject to a more arduous review. We shortened the period of past agreements that are going to be going to the Attorney General's office to 2 years. As drafted, there was no limitation. So the first question I had from a city was, do we have to find agreements from the last 100 years? No, the AG's office doesn't want to take a look at every contingency fee contract we've ever entered into. They just want more recent and then more recent and then prospective, and then clarifying that the Attorney General has the option to take over the claim and recover on behalf of the city instead of just extinguishing the claim, which that right is in the contract. There's one section that, Madam Chair, your question highlighted. There's one section that we still have not reached agreement on. It's better than it was. It's better than it is in the bill, but we are still working with the AG's office and welcome the ability to work with them to refine that. We still think the language too broad as drafted. We hope to continue that dialogue to better refine that, capture all those suits that are needed for a statewide approach, but preserve localities' ability to individually pursue claims that where there's an individual specific identifiable harm that's unlikely to be captured with a statewide approach. So we're grateful for the opportunity to weigh in on the bill, and Madam Chair, we would ask that this committee consider and adopt the amendments that have been agreed to by the conferees before moving this to the full Senate if you choose to do so. I'll stand for the questions at the appropriate time.
Thank you. Yes, we'll hear from all the neutral conferees, and then we'll open it up for questions.
Thank you.
Thank you. Next, we will hear from Travis Harrod, Deputy Director, Court Trustees, Integrated Trustee Services. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, members of the committee. Madam Chair, I am Travis Harrod. I work for Integrated Trustee Services along with my colleague Kendall McVeigh. We submitted written testimony. I'll just touch on just the thing that jumps out of the bill to us and caused us a little bit of concern. As district court trustees, we're enabled under Kansas statute and Chapter 20, Section 3, that just says the courts can go and find a district court trustee to help them enforce orders of the court, and it's written very narrowly to say orders of support being child support, spousal maintenance, and then to recoup restitution that may have been ordered as part of a criminal proceeding on behalf of a victim. And so this is to make sure that the orders of the court are obeyed, but also to save private litigants from having to go find a private attorney and pay their fees to bring in this court-ordered money. When my colleague Kendall McVeigh and I saw the bill as written, we had no opposition to it, and having heard the proponents here today, we understand what they're trying to do, but we had a concern that in the definitions section on the third page, which I think is subsection E, as far as political subdivision, it was written to say basically any governmental entity that gets public funds. And so maybe that includes courts, and then of course contingency fee. As the court trustee statute is currently written, well, one of the ways that court trustees can be remunerated is by taking 5% of what they collect on behalf of the parties. And so it seemed like if you cast the net broad enough, it might conceivably bring in the district court trustees. And we were hoping that this committee would consider exempting district court trustees as contemplated by our Kansas statutes. And when you look at, like I said, Chapter 20, Section 3, you're going to see that the powers of the district court trustees are really, really very limited. Just enforce orders of support for the court and recoup restitution. The trustees aren't going to go out and sue anybody on behalf of the court. They're certainly not going to go out and be used to bring suit for a local government or any sort of agency like that. So we're hoping that we would take a look at the statute and either put in some sort of exemption or perhaps narrow a definition here or there or something, and just let the district court trustees just go on their way. That's all I have for you, and I'd stand for questions when that time comes.
Thank you. Appreciate your testimony.
Thank you.
Next, we will hear from Larry Zimmerman, Kansas Creditor Attorney Association. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, members of the committee. I appreciate the opportunity to be here, and I won't belabor the points that have already been made too much. I just want to highlight, as a member of the Kansas Creditor Attorney Association, we are offering neutral testimony on this, simply trying to make sure the committee is aware of some of the unintended consequences we observed in the original draft of the bill. We are collection attorneys that are the exact opposite of the high-flying class action attorneys with political and social issues of concern. We are predominantly focused on making sure that individual municipalities, political subdivisions, are able to enforce orders of the court, are able to collect debts that are owed, are able to collect restitution, fees, and fines. That's all we do. Our cases are brought locally, they're conducted locally. Doesn't intrude onto the area of a broader state interest or broader social interest. Our primary concern was the draft of the bill as it existed picks the most broad definition of political subdivision possible. And I put in my written testimony kind of breaking that out into a list so you could see, and it covers any and all contracts for all time, contingency fee contracts. That's going to suck in way more than the $5,000 in filing cabinet they talk about in the fiscal note. If they continued with that drafting, they would be getting a semi-truckload at least of contracts to review, and I simply don't think that was the intended consequence. That said, I will say that the proposed balloon amendment that we've seen that exempts out those kinds of contracts that are purely local, that don't reflect a greater social or political issue, would resolve the concerns and issues that we have. And with that, I conclude my testimony and would be available for questioning at the appropriate time. Thank you.
Thank you. Are there any other persons wishing to testify as neutral conferees on the bill? Not seeing any, then we'll open it up for any questions. Senator Corson.
Thank you. Thank you, Madam Chair. Question for our court trustees. Do you know if the issue that you presented if that is addressed in the prospective balloon that we're, I think, going to be forthcoming? Do you have any knowledge one way or the other on that?
And before you reintroduce yourself and answer the question, since we're talking about the amendment, thank you for bringing that up again. There's been talk about a balloon amendment, and just want to be clear for the record that it's not an amendment marked with balloons and arrows from our revisor's office, as I understand. It's an amendment offered by the proponent who's going to turn it in as an amendment, but it's not been through the revisor's office. So just want to clear that up. So, but go ahead.
Yes, Travis Herod, District Court Trustee. We did suggest some language, and I think I'm told that yes, I believe it was included as far as some suggested language that might help exempt District Court trustees from SB 242.
That's great. I'm glad to hear that. Thank you, Madam Chair.
Thank you.
Thank you. Senator Titus.
Thank you, Madam Chair. Mr. Goodyear, question for you.
Please reintroduce yourself.
John Goodyear from the League of Kansas Municipalities.
So in looking at this issue, I'm reminded of the city of Mulberry versus BP Energy, where a very small city in the price gouging after Winter Storm, or alleged price gouging after Winter Storm Uri, brought a claim and won for gas costs. And I wonder, the Attorney General's office tried several times to put together a case, ultimately didn't. Do you believe under this bill and the bill is amended, a city like Mulberry, it would be at the whim of the Attorney General whether this was a statewide claim or not, and they might be precluded from a case they successfully prosecuted but the state couldn't?
Sorry, Senator, I'm just thinking through your question. Potentially, yes. Yeah. If the contract was submitted for review and the Attorney General's office deemed that this was a matter within the state's purview or that was not a matter of purely local concern, the Attorney General's office could cancel that claim.
Do you think that line is clear between what's a statewide issue and what's specifically a local issue in this bill?
Thank you for the question, Senator. I would like to make it more clear, and that's part of the definitions that we're working out. It was mentioned by the proponents that this discussion kind of started 5 years ago, and we've been negotiating with two different Attorney General's offices over 5 years to make this workable, and it's a lot better than the bill that came before us. It's not perfect, and that's why we have cities that will oppose it, but knowing that this something like this may move, acknowledging the competing interests, so we thought it was in our best interest to just make it as good as we could.
Thank you.
Thank you, Senator.
Thank you. Other questions? Not seeing any. Thank you very much. We will next hear from opponent conferee Shannon Kimball, Government Relations Specialist, Kansas Association of School Boards. Please introduce yourself and welcome to committee.
Good morning, Chair. Oh, that's loud. Excuse me. A little too close. Good morning, Chair Warren and members of the committee. Thank you for the opportunity to appear today. I'm Shannon Kimball, Government Relations Specialist with the Kansas Association of School Boards. KASB represents nearly 2,000 locally elected school board members in 285 school districts across the state. These 285 units of local government would be subject to the requirements in the proposal in Senate Bill 242. Our member adopted legislative policies, which are in our excerpted in our written testimony, rest on the bedrock principle of local control. School boards are the constitutionally designated governing body charged by the people of Kansas with the general authority to maintain, operate, and develop local public schools. These school board members have a fiduciary duty to act in the best interests of their school districts, which includes the traditional duties you think of in a corporate sense, duty of care, duty to exercise reasonable care in their decision making. We believe that Senate Bill 242 would override that local control and interfere with that duty of care by potentially removing decision-making authority from those elected officials regarding how best to carry out their fiduciary duties to their districts. Regarding the need for potential legal services. And it would really give the Attorney General's office the ultimate authority over those decisions with no avenue for an appeal process or otherwise regarding the Attorney General's ultimate decision. This is, in our view, plain and simple, just an overreach into local decision-making about these matters, because it is the local elected board's work, both historically and by law in Kansas, and I provided a couple of statutes in my testimony that describe the authority and duties of local boards of education. We have some specific, beyond the overreach issue, we have some specific additional concerns. Our testimony is solely based on the text in the bill as proposed. We have not seen the proposed amendments, so I'm not speaking to that today. Excuse me. Those concerns include that the approval process is quite lengthy, and as I mentioned, lacks any appeal process to disagree with the Attorney General's decision. And it's also duplicative on the issue of transparency. I want to make very clear for the members of the committee that anytime a local school board would consider entering into one of these contracts, it would have to be approved at a noticed meeting of the Board of Education in public, just like any other kind of contract that a Board of Education enters. And there would be an opportunity for public input on that. So I do not believe that as these contracts have been used by local school boards, that there is an issue of transparency here that needs to be addressed. Second, the approval process, as it is outlined in the bill, seeks release of what we believe could be privileged communications between a Board of Education, particularly where that Board of Education has done its due diligence and, for example, consulted with its own hourly paid outside counsel. Boards of Education generally have outside counsel that they engage to do their business. I can speak from experience in this. My district that I sit on a school board for did engage in one of these kind of lawsuits. And when we did that, we engaged our outside counsel to give us advice on the merits of the legal claim that was being proposed, as well as the contents of the contract before we took it to an open meeting to approve it. So we did that vetting process, and that list of things that are asked to be disclosed both in the notice of the meeting and then in the communication to the Attorney General's office steps into those privileged communications in a way that I don't think is appropriate, and that our members would ask you to consider it as not appropriate. Finally, the process in terms of the reasons that the Attorney General can refuse to approve one of these contracts, as written in the bill, are extremely broad. And I don't believe that it's, that as written, or even as the Bloom Amendment has been described, it appropriately describes what is a realistic line between matters of local concern and matters of statewide concern. Senator Titus brought up the Winter Storm Uri example. Local boards did not engage in a class action lawsuit. School districts did not related to that. But they might have, and they might have all had varying degrees of damages from the alleged price gouging in that circumstance. An example of, I'm getting close
So
to my
yes,
time.
just wrap up that thought. Time is up.
Sure. An example of how this has been successfully used in Kansas by certain school districts was the Jewel litigation. I would be happy to answer questions further about that, and thank you for your time this morning.
Sure, thank you, appreciate it. Are there any other opponent conferees wishing to testify? Not seeing any, then want to draw committee's attention at your desk. You have opponent written-only testimony from Amanda Stanley, City Attorney, City of Topeka, Michael Koss, City Attorney, City of Overland Park, Jay Hall, Deputy Director and General Counsel, Kansas Association of Counties, Jennifer Magana, Director of Law, City Attorney, City of Wichita, and Ryan Beatty, Chairman, Board of County Commissioners of Sedgwick County. And with that, we'll open it up for any questions. I have one question for Ms. Kimball. You said that currently the contracts are reviewed at public meeting. Does that mean the contents of the contracts in current practice are disclosed to the public and made a public record?
Yes.
If you'll reintroduce yourself, that would be helpful.
My apologies. Shannon Kimball, Kansas Association of School Boards. Yes, that would be the practice. As was indicated, if you talk about something like that in an open meeting, it becomes part of the documents that are open to the public.
Sure, understood. Just wanted to know if that was the current practice at the school board level meetings.
Yes, I believe so. Thank you.
Appreciate it. Thank you. Any other questions? Not seeing any, then thank you everyone for your testimony today. And we will close the hearing on Senate Bill 242. We will next open the hearing on House Bill 2134, amending the Kansas Open Records Act regarding charges for records in the state executive branch and other public agencies other than the state legislative and judicial branches, prohibiting charges for electronic copies of records and for determining whether a record exists, and limiting charges for employee time required to make records available. With that, a bill brief from the reviser.
Thank you, Madam Chair. House Bill 2134 was substantially amended over in the House Committee on Judiciary, so I'm just going to focus on what the bill does now in its current form, and then I can take any specific questions if you have them about the way it was originally introduced. The bill amends KSA 45219. This is the statute in the Open Records Act that relates to obtaining copies of public records. Subsection C in current law there provides that unless otherwise provided by law, each public agency may prescribe reasonable fees for providing access to or furnishing copies of public records. This bill would add a provision that the actual cost of furnishing records may include the cost to review and redact the requested records, but shall not include incidental costs incurred by the public agency that are not attributable to furnishing the requested records. Additionally, if the public agency incurs costs for staff time to furnish those records, the agency shall use in good faith the lowest cost category of staff reasonably necessary to provide access to or furnish copies of the records. Charges for staff time shall be based on the employee's salary or hourly wage and shall not include the cost of employee benefits. When staff time needed to respond to the records request will exceed 5 hours or an estimated cost of $200, the agency shall make reasonable efforts to contact the requester and engage in interactive communication about mitigating the costs to fill the request. The requester is not obligated to mitigate costs. And if a public agency has made reasonable efforts to contact the requester and the requester has failed to respond by the end of the 3rd business day, then the records request shall be deemed withdrawn until a subsequent contact has been made by the requester. Reasonable efforts to contact the requester is defined in the bill, and it means contacting the requester through the means of communication that they provided to be used for the agency response to the open records request. And I can take any questions.
Thank you. Committee questions. Senator Titus.
So to compare this bill to the Senate Bill 70, which had some similar changes that we worked on, this basically, we're getting rid of copy fees, and the only charges are for the actual cost of producing the records now. Is that the correct summary?
Madam Chair, Senator Titus, are you asking me what the provision you guys put forward?
Instead of two categories of potential charges, a copy fee and actual time, this is just the only charges are just whatever the actual costs to produce the records are under this bill, right?
Madam Chair, yes. And then it obviously goes into further detail about how those actual costs are supposed to be determined, but yes.
There's no copy fee anymore. That's just in the actual costs.
Correct, yeah.
Okay, thank you.
So when he said there's no copy fee anymore, that's just in the actual cost. Is there a per page copy fee in this bill?
Let me find the per page copy, where that was. So you'll see, as the bill was originally introduced, on page 2 at line 26, it had that copy fee there for the equal to 25 cents per page, but that was removed in the House amendments.
Thank you. Senator Corson.
Thanks, Madam Chair. Pretty much similar to what Senator Titus asked. If I guess my question is I'll put it most simply the way I'm thinking about it. If we passed both Senate Bill 70 and then we passed this bill, is there anything in either of them that is contradictory to the other that would not be a good thing to have in statute, these two laws? Do they conflict in any way, or do they both work together in ways that make sense from a codifying in statute perspective?
Madam Chair, Senator Corson, I think probably you would want to analyze them both together because there are some inconsistencies. For example, like on page 2, in reference to that 25 cents per copy fee in what would now be subsection D. So current law there allows that 25 cent per page fee, and you guys retained that in Senate Bill 70, but you said that no fee can be charged for electronic copies, and that's different than what you have here. So I think that you would probably want to look at those two things together and make some decisions about, for example, like the electronic fees, that's not addressed here. So if you want that policy to go forward, you'd have to add that in somewhere.
So it sounds like we do need to, at some point, marry these up and make sure that we're not, it sounds like passing both of them as they're currently written would be problematic and contradictory, and that we need to marry them up maybe in conference or somewhere else. So we have a clean statute at the end of the day when these are codified, is kind of what I'm hearing from you. Is that accurate?
Yes, Madam Chair, I think that's fair. The policy from both bills could be married together. I don't want to say you can't pass the policy that's in both, but in terms of the drafting, I think you'd want to, make sure that those flow together better.
Yeah, it sounds like the policy pieces could work, but the literal language, we need to make sure we're synced up. Yeah. All right, well, thank you. That was very helpful. I appreciate it.
Thank you. Any other questions? Not seeing any. Thank you. Appreciate it. So our first proponent conferee we will hear from is Dave Trabert, Chief Executive Officer, Kansas Policy Institute. Please introduce yourself and welcome to committee. And we're going to limit testimony to 4 minutes for everybody. Thank you. I think he's on WebEx.
I am. Thank you, Madam Chair, members of the committee. I'm sure I can get this done in less than 4 minutes. The House Bill 2134 as amended does allow local units of government to charge printing costs, but no more than the actual printing costs. The issue we were trying to resolve in the original bills in House and Senate is that some entities are charging more than actual cost. In other words, we see, for example, they will charge for the employee time and they charge 25 cents per page. It doesn't cost 25 cents per page. I think the original intent of the language may have been that 25 cents obviously is more than actual, so that's one way of doing it. And unfortunately, we've seen some local entities try to double dip. So if as 2134 is written, And this represents a compromise that was worked out between the League of Kansas Municipalities and Kansas Policy Institute, so that actual costs can be recouped, but not more than actual costs. So you can recoup the employee time and the actual cost of printing a piece of paper. It doesn't cost anything to attach an electronic file to an email, although that's something that some local entities had tried to do. So the cost of gathering information that is provided electronically can still be recouped under 2134 as amended, but no additional per page charges, which basically amount to double charging because the cost of producing has been recouped and there is no cost to attach an email. Senate Bill 70 had a little bit different way of describing costs that had given the Kansas Register of Deeds Association some heartburn. And so we also worked out with them, they have said that they've looked over House Bill 2134 as amended, and now they agree that this also resolves their issues. And with the addition of the coma language that was in Senate Bill 70, we would propose just bringing that in to House Bill 2134 as amended. And we hope that you would recommend that favorably for passage. And with that, I'll be happy to answer questions.
Thank you. If you'll stand by, we'll take questions at the end of the conferee testimony. Next, we will hear, thank you. Next, we will hear from Matthew Bingesser, Administrative Counsel, Office of Attorney General. Please introduce yourself and welcome to committee.
Thank you, Madam Chairwoman, Senator Corson, Ranking Member, and members of the committee. I'm Matt Bingesser, the Administrative Counsel at the Office of the Attorney General. The Attorney General is the agency charged with enforcing open records and open meetings laws in the state of Kansas. It's a bifurcated program. Amber Smith does our initial enforcement, and I'm the guy you get to see after an enforcement has been made against you. They're doing the open government training and education program in the state of Kansas. And so we have reviewed this bill. I think it is a well-drafted compromise. So we do thank the League of Kansas Municipalities and Kansas Policy Institute for coming together and making this a compromise a reality. My only ask is that you do include the components of SB 70 that relate to the bad actors intervention program and the records that relate to an investigation that is closed that was administrative in nature. So those components can continue on in the ultimate package. I suspect Senator Corson is correct that some conference report or some merger of the bills will need to take place. We do ask that those components be re-added in there when the time comes. So I appreciate your guys' work on this. It's a well-drafted bill, and I will stand for questions at the appropriate time.
Thank you. Next, we will hear from John Goodyear, General Counsel, League of Kansas Municipalities. Please introduce yourself and welcome again to committee.
Thank you again, Madam Chair. John Goodyear from the League of Kansas Municipalities. I serve as General Counsel. I'm talking too much already today. Thankful for the opportunity to appear again, this time on House Bill 2134. If you remember, consistently on these Corey bills, we are always tend to be on the opposite side of the Kansas Policy Institute, and the same was true on this bill. They supported it, we opposed it on the House side. Senate Bill 70, we supported it, they opposed it, and that has been true for years. And following the hearing on 2134, Senate Bill 70 was heard the same day. Both sides finally got together and hashed this out, and the bill that you have before you, the House took our recommendations. I'm grateful for that. The bill that you have before you is a product of 8 days of negotiations. I think it ended up being constant emails back and forth. Tremendous work with them to find something that preserves that local ability to recoup our costs, not to profit, but we want to recoup our costs, but also clarifies what those actual costs include. We also, just of note, created an obligation in law to do what has largely been best practice, and I hope most of our cities are doing it already, but engaging in interactive communication with the requester when a significant request comes to a public agency to see what we can do to refine those requests, to mitigate costs. I think that's going to be a tremendous step in solving both sides of this issue. Again, grateful to Mr. Trobert to Mr. Franco at the Kansas Policy Institute. As we negotiated this, we had a number of different cities weigh in. The Association of Counties weighed in. The Press Association weighed in. The Chiefs of Police and Sheriff's Associations weighed in. So this is a well vetted compromise. It's not perfect for either side. To quote one of my cities, they said we can work with it, which means it's probably a decent agreement. But again, grateful to this committee for hearing it. Grateful to the other conferees for working this out. Grateful to the House Committee for adopting our amendments, and that we would request that if this moves forward, that it do so largely in its current form. All right, and with that, Madam Chair, I'll stand for questions at the appropriate time.
Thank you. Appreciate it. Is there anyone else wishing to testify as proponent conferee? Not seeing any, then committee, I'll draw your attention to proponent written-only testimony from Amanda Stanley, City Attorney, City of Topeka, Ed Klump, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, Jay Hall, Deputy Director and General Counsel, Kansas Association of Counties, and Wendy Weiss, on behalf of Kansas Register of Deeds Association. With that, we'll open it up for any questions. Not seeing any, then thank you very much for your testimony. We will now hear from neutral conferee Clay Barker, General Counsel, Deputy Secretary of State. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Clay Barker, General Counsel, Kansas Secretary of State. Our position on the bill is, I'd probably frame it as neutral but very supportive. We're neutral because it doesn't affect our office directly. In 6 years of doing core requests, I've only charged and collected from 2 people out of hundreds of requests, and they were law firms that blew their discovery deadline in a trial and were trying to go around the system. And the fact that our Cora email is cora@ks.gov means I get a lot of requests from people and I have to police them in traffic and send them to the right agency. But 4 quick points on the bill we'd just like to make. First, we appreciate very much clarifying the fees that can and cannot be charged, because when we get into fights with what we think is an unreasonable request, the requester obviously thinks it's reasonable. If you can line up what it would cost, that often creates a desire for negotiation to get down to what you want. And an unreasonable request would be one where someone asks for every email that mentions the Assistant Secretary of State for the last 5 years. And when we checked, that was over 60,000 emails, and this person insisted we produce them all. And that would require someone to go through each one, because it wasn't limited by subject, to decide, is this exempt? Is it cybersecurity? Is it personnel issues? Is it drafts? And being able to give them a cost and time estimate caused them to back off. Second point, the provision about lowest cost, and we look at the phrase in good faith. In our office, I'm probably one of the higher hourly employees if you looked at my cost, but because I actually know everything about the agency, where everything is, I'm so much faster than anybody else that if we actually charged, it would be cheaper for the requester to have me do it, even though it looks like they're trying to put it on a higher cost person. Third point, I understand the purpose of the bill. There's another part of Cora that Kansas has seen a little bit of. Other states have been swamped with it. It's the weaponization of Cora requests, especially on election officers, flooding them with requests, intentionally trying to disrupt their operations. So I appreciate the provision in there about if there's no response in 3 days, you can consider the Cora request gone. And I've got quite a few that I respond and no one comes back. I didn't know when to cut them off. But a lot of these requests, the person requesting has no idea what they're asking for. They're taking a template from a national group and just firing it off. And if you get back to them and say, well, what exactly do you mean by this term? They don't respond. Or when I get a request that was sent at 3 in the morning, I know somebody's been watching Telegram or YouTube videos and just got an idea and sent it off. And my last point is, although I deal with hundreds of regular Cora requests, our business records and voter rolls are governed by unique statutory provisions that tell us what we have to charge. And we've always understood that because those are special, narrow provisions passed by the legislature, that even though they're for public records, that takes them out from Cora. We have tens of thousands of business record requests. Those are all free, they're online. But certified documents, database dumps, those are always made up of a base fee, which goes to SGF, and then a tech fee and an admin fee, which stays with our office. And again, those are set by the legislature specifically for those types of records, and we've always understood those to be outside of the general Cora scope. And with that, Madam Chair, I'll ask for questions, or stand for questions at the appropriate time.
Thank you. Appreciate it. Do we have anyone else wishing to testify as neutral on the bill? Not seeing anyone, then want to draw your attention to neutral written testimony from Michael Koss, City Attorney, City of Overland Park, and open it up for any questions. Any questions? Mr. Barker, I have a question for you. You said that though you would be at a higher pay rate than others, you could get the job done probably more efficiently. Does the Secretary of State's office have any concern what if we have two salaried employees and there's no, I mean, there is kind of an effective hourly rate that you could calculate, but it's two salaried positions. Would they be equal then, and whoever had time could answer, or what would the Secretary of State's office be position on that?
Madam Chair, we've never had to face that because we've never charged anyone except for the two law firms. We would always try to get the person the lowest cost, but it's just that because I know where all the nooks and crannies are in the agency, we do so many things. Almost all our records are digitized. I have them on my computer. It takes me 5 minutes to respond to a request, that I just handle it all. I also know the exemptions in my head so I can spot them. If I need something from my, say, our IT department to scan for things, I'll just ask them. But it's the good faith effort to give the requester the cheapest cost possible means sometimes you actually have a higher paid person do it just because they have that broad expertise and specialization. But again, the way we read it is the agency would have to get the requester the cheapest cost possible.
And it's written very clearly that you can determine, as the entity responding to the CORA request, you can determine what the lowest cost employee would be. That's a yes.
Yes.
Okay, sorry, it was not audible, so for our record, but thank you. Any other questions? Not seeing any, then thank you very much. Appreciate the testimony. Do we have anyone wishing to testify as opponent on the bill? Not seeing any, then we will close the hearing on House Bill 2134 and open the hearing on House Bill 2166. It's continuing in existence certain exceptions to the disclosure of public records under the Open Records Act. And you'll hear from the reviser that this is an annual bill that the legislature has to hear and act on every year regarding whether we're going to continue exceptions to disclosing of certain public records under CORA. So with that, Ms. Scott.
Thank you, Madam Chair. House Bill 2166 is going to be the most action-packed, fun bill you guys hear this year. It's the only one that's brought to you by our office. The statute in the Open Records Act requires our office to certify to the President of the Senate and the Speaker of the House every year what open records exceptions are going to expire on July 1st of that year. As you've probably noticed, when you guys create a new exception to the Open Records Act, you expire that exception in 5 years and say that you will then review that exception and decide whether it should still continue into existence in 5 years. So we go through the statutes and we bring you a bill that would continue those exceptions, and we ask that you review them. The statute actually requires you to consider what specific records are affected by the exception, whom does the exception uniquely affect as opposed to the general public, what is the identifiable public purpose or goal of the exception, and whether the information contained in the records may be obtained readily by alternative means and how it may be obtained. So you will see here we provided you a packet. This year we're reviewing the 2020 exceptions that you created. 2020 was a pretty slow year in terms of legislation being passed because your session was cut short, so you only have 2 exceptions that you created in 2020, and you'll see in the packet here the text of those exceptions that you're reviewing and proposing to continue. So if you have any questions, I can take those.
Thank you. So you're testifying not only as our reviser, but also on the bill content as well. So it would be appropriate to ask questions about the content of the bill to Ms. Scott, but not seeing any. So it looks like you did an exceptional job. So appreciate that. Thank you. Committee, we do continue to have a busy week. I want to look at meeting minutes from February 10th, 11th, 12th, 13th, and 14th of 2025 that have been submitted for your review and approval. So Do we have any discussion or a motion regarding the meeting minutes from the week of February 10th? Senator Corson.
Thank you, Madam Chair. I would move to approve the minutes as written.
Thank you. Is there a second? Senator Bowser with the second. Any discussion? Not seeing any. Did you want to close on your motion?
I close, Madam Chair.
Thank you. You all have heard the motion. All those in favor signify by saying aye. All those opposed, no. The motion carries. We do have a few minutes here for possible final action on bills previously heard. We've had robust hearings today, so we're not going to do that today, but please do have any amendments that you want to bring. Please bring those to my attention on bills as we hear them, because we want to be ready for final action. We only have until, I think, March 18th is our last opportunity to meet as a committee and get our committee work done. So with that then, want to thank your attention today, whether you're following online in the committee meeting room, thank our conferees, thank our members, and of course our staff. So with that,